we're going to pick up with legal considerations. Now, this is not huge on the exam. One of the things that I feel like is that because CISSP exam is gaining popularity worldwide, there's a lot less concern and a lot less focus really on U.S.-based law. So it being the international exam that it is, at one point in time, I think you probably would have seen more U.S. laws, Fraud and Abuse Act, and some of the others. But I would tell you, we'll go through this pretty quickly. I'll try to direct your attention to things that are test-worthy. But for the most part, like I said, we'll cover it appropriate for the exam. All right? So moving forward, when we talk about legal considerations, I have been entrusted to protect the resources, the assets of the organization. That's my responsibility. That's my job. So if at any point in time our organization suffers a loss and it can be shown that I was culpably negligent, well, yeah, then I'll be held liable and I'll be subject in all likelihood to a fine and perhaps some other recourse, right? So as a senior executive, I want to make sure that I'm protecting my assets. All right, I got a question for you. Okay, put on your thinking cap. You have a system, so it's your system, and you've connected it to the internet. Your system is compromised by an attacker, and it's used to launch a downstream attack on another organization, causing thousands of dollars worth of damage. Okay, if you're with me. So it's your computer, you hooked it up to the internet, an attacker compromised it, is using it to launch an attack, causing thousands of dollars worth of damage. And the question I have for you is, are you liable? Are you liable? So I know some of you will say, no, not my responsibility. Some of you will say, absolutely. But my favorite answer at any given time is maybe. That's as good an answer as you're going to get. And that really is the answer here, maybe. So how do I qualify this? Well, let me ask you another question. Can you secure a system in such a way it is impossible to breach? I have a system so secure that no one can compromise it, short of dumping it into cement or any of those things, right? I can't. The very nature of networking is to share, and that in and of itself is contradictory to security. So I can't build a system, manage a system that I can guarantee can't be compromised. So what can I do? I don't want to be found liable. I don't want my systems used to launch attacks. I don't want that to be my liability. So what can I do? Well, I can use due care and due diligence, and I can do what's right. I can follow industry standards. I can educate myself in the latest threats, the security trends, and I can do the best I can. And in short, what that means is I've acted as a prudent person would act. I've acted responsibly and cautiously, and that is a term that comes up in court for liability, meaning that I've acted responsibly and cautiously. Okay. Due care and due diligence, not official legal terms, but due diligence, just think of it as the research, and due care is the action. So if I want to avoid liability, I have to do what's within reason in order to protect the company assets, right? And we talked about that on Tuesday. We talked about doing our cost-benefit analysis. We talked about making good business decisions for how we control our assets. So this is just kind of a little bit of a refresher. And you'll see a bullet point towards the bottom. Downstream liabilities is just referenced here. All I want to mention about that, a downstream liability is if I outsource an activity to a third party, I can outsource work, but I cannot outsource responsibility. And I think we talked about that on Tuesday as well, right? I'm ultimately liable for my customers' information. Even if I hire somebody else to process it, I'm still liable. Okay, so just wanted to review that. Now, very quickly, I'm going to hit some ideas on the types of laws. Again, I'd really kind of be surprised if we see this on the exam till we get to intellectual property. And intellectual property is always a hot topic. So we'll get there. All right, so just quickly to mention criminal law. And criminal law is difficult to get a conviction for computer crime in criminal law because the burden of proof is quite high. It's beyond a reasonable doubt. And if you have 12 jurors that don't understand technology and you bring a cryptography expert in that wants to talk for 3 days about the likelihood of collisions happening with SHA-256, you're going to put the jury to sleep, and there's your reasonable doubt, right? So technical details are hard. A lot of people don't understand it. I would be willing to bet that 50% of the general population really thinks that elves and gnomes run the internet and make it happen. It's going to be really hard to get that conviction in criminal law, which is why sometimes you see when someone is acquitted in criminal law, then the victims or the alleged victims will sue them in criminal court. So criminal court is for laws against, for damage against an individual or an organization. This is sometimes called tort law. But here, the burden of proof is the preponderance of evidence. So essentially, the majority of the evidence is going to indicate a certain rule, right? And then we have administrative law, where we have particularly law that affects businesses and organizations and for particular industries that are controlled by regulation. So banking, you've got Basel II here for banking. Graham Leach Bliley is for banking. There is HIPAA with healthcare information. And for administrative law, once again, it's more likely than not. So it's the majority of evidence and much less burden of proof. The reason criminal law has such a high burden of proof is that a punishment could be jail time. So we have to have a very high burden of proof there. All right, so those are the three sort of types of laws. Wouldn't spend a lot of time there. It is worth a mention to talk about intellectual property law. So, we hear a lot about this. We hear about piracy. We hear about licensing issues. We hear about copyright violations. Certainly, that's very relevant today's time. So when we talk about intellectual property, we're talking about protecting property of the mind. Right? We're talking about inventions and ideas and logos and all of these things that are unique to us. So first of all, it's worth a mention that the UN runs an international organization called WIPO that's dedicated to investigating and pursuing copyright violations. And once again, it comes to us from the UN, so it must be good. All right, licensing is the most prevalent violation that we see, and many organizations are doing a lot of different things to cut back on licensing issues, but it's still there, even though it's in lesser degree. All right, so let's talk about some of the different types of intellectual property, and the first is a trade secret. All right, so with a trade secret, it's something that gives my company a unique value. It gives us an edge in the marketplace. It's a secret that we have that sets us apart from others. So we're going to go down the McDonald's trail here. The secret sauce in the McDonald's Big Mac, that is a trade secret for them. Okay? Now, one of the things that might limit that is it must be reasonably protected and it must be secret. It can't be obvious. So, if you're just thinking it's pretty much Thousand Island dressing, well, if that's true, because I don't know the secret sauce of the Big Mac really, but if that's all it is, it being genuine, that being obvious would kind of take it out of the picture. But a trade secret, it's what we do differently than others. It's what makes us unique.